Hi, it's Richard Hughes with the Hughes Law Firm. Well, I am going to give you a little bit of information on a campaign that I have been waging here over the past 4 months, encouraging my clients to update their documents to adapt to two new laws. Now, the documents that I want them to update include the Colorado statutory power of attorney and the living will. As a quick refresher, a power of attorney is a document that you would use to appoint someone you trust to take care of affairs for you, financial affairs, if you become disabled. Let's say you have a stroke, or you get Alzheimer's or dementia, or you have a nasty fall and you've got a head injury. If that happens, you're going to be in deep trouble because no one's going to be available legally to write checks for you, pay your bills, deal with your investments, rental property, IRA, you name it. So we've got to have powers of attorney out there to have folks in place to manage our affairs. If we fail to take care of that, then the family has to go to court and have a judge pick somebody to do that job. That process is called, well, we call it a living probate, but it's really technically referred to as a conservatorship. So the judge appoints a person called a conservator, who could be a family member, a friend, but oftentimes a totally disinterested person that is an administrator picked by judges a lot to run the financial show for people that are disabled who failed to plan for their disability. So this new power of attorney is really necessary today because we had a new law that went into effect January 1 of 2010, making your old power of attorney for all practical purposes obsolete. Here's why. The new power of attorney makes it clear that there are certain powers, very sensitive ones, that are called hot powers, and they need to be clearly listed in your power of attorney. Hot powers include such things as the power to make gifts. In other words, your agent cannot make gifts to, let's say, help you plan to qualify for Medicaid unless there are powers specifically listed in the power of attorney to authorize gift making. Another big time power that's a hot power is a power to change beneficiaries on life insurance. Now, not everybody wants their agent to have that power, but if you do, you got to have it specifically in the power of attorney. Also, the power to change the beneficiary on a bank account. We call those PODs, or in some brokerage accounts they're referred to as TOD, transfer on death. So you can't have a power of attorney without those powers if you want your agent under a power of attorney to have the ability to make adjustments for you. So it's real important to get this new statutory power of attorney. We prepare those for our clients. It's a relatively inexpensive process, and it's one which I think is necessary so that you can keep your saw sharp and be ready for whatever comes down the road. Why is that really critical? Well, powers of attorney are rejected often anyway because they get too old. Banks don't like old powers of attorney. Brokerage firms don't like old powers of attorney. Title insurance companies don't like old powers of attorney. And now with the new law, they're going to be looking to see if your old or new power of attorney is up to snuff with the current law. So get the right stuff. Keep your, as I said, saw sharpened, and I think you're going to be in a much better position if you become sick to have a court-free administration of your affairs financially in the event you suffer from some disability that takes away your ability to make your own decisions. The other document that we are urging our clients to update is their living will. The living will is the legal document that says pull the plug if 2 doctors certify I'm in a terminal condition. Now, the big change in the living will law is to authorize the pulling of the plug for what is known as persistent vegetative state. PVS, I will call it for the sake of brevity. PVS is where you are still alive, but you don't even know it. You're being kept alive by food tubes, perhaps a ventilator, and it may even look like you are aware of what's going on, but in reality, you are not. This is a big time change in the law. Under the old living will law, there was no provision for allowing doctors to discontinue life support if you were suffering from a PVS. Now it allows that, which is very important to many people because they can remember the Terri Schiavo disaster that occurred years ago, and actually back in about 1995, and it lasted, I don't know, 3 or 4 years. We don't want that. We want the world to know what we want, and we don't want to be kept alive by food tubes and machines if we're suffering from PVS. Now under the new law we can make that clear. Now this new living will law does not make your old living will invalid or void, but it does muddy the waters. Why? Well, doctors don't have time to be dealing with this legal stuff. So when it comes time to make a decision on whether or not to pull the plug, they don't know whether or not this old living will is going to get the job done or whether you needed a new living will. They have to go consult and study and deal with this topic, and it's time consuming and it's stressful, and it can be very expensive if it ends up in court. So make it easy on doctors. Get your new living will that complies with the new law that says you want, if you choose, to have life support systems discontinued in the event of PVS. What we're doing is helping our clients financially get this done, so it's an update process they don't have to think twice about. I can tell you more about it if you'd like to contact me. Please feel free to do so. Phone number is 303-758-0680. Once again, it's Richard Hughes, 303-758-0680. Call me if you've got questions in this area. I'll help bring you up to speed. Thanks a lot for watching.